there, and welcome to yet another scintillating edition of the program CAC Weekly. Now, CAC Weekly is that weekly program that keeps you abreast on the activities and the achievements of the Corporate Affairs Commission. I am Amina Jibril. Coming up on CAC Weekly, Labour Union applauds CAC's achievement as Court of Appeal rules on jurisdictions of labour unions. Also, the Institute of Charter Secretaries and Administrators of Nigeria partners CAC to enhance service delivery as the Commission sets to axe dormant business names and incorporated trustees from the register. Plus, more on Africa's first beneficial ownership register right after this break. Do stay with us.
Realizing that a lot of these companies are still in our books, some are actually doing transactions. We are collaborating with stakeholders, with other stakeholders like the insurance sector, the banking regulators, and other sectoral regulators to make it mandatory that for any licensing review or renewal of licensing, the entity must first and foremost update this information with CAC. Because one thing we tend to forget, before they approach any regulator, before a company approaches any regulator or license, it must be registered by the CAC, it must be elected. And if the company does not update this information with CAC, then it's an indication that they are running away from something. The CAC register is the only register that is publicly available. Any member from anywhere is entitled to access information from the CAC. If you want to remain opaque, don't register a company. If you have a company, then the information about you and about your company is public information, and any member of the public can access. But if you think you can do business under your forename and surname without any addition, they don't allow you. You can carry on business. In these days, I think it's only trading that you can do in your forename and surname. Most other businesses are subject to other forms of regulation, and the regulator will insist that you must have registered entity.
Welcome back to the program. Now let's begin today with another delightful news for the CAC, as the National Executive Council of the Senior Staff Association of Statutory Corporations and Government-Owned Companies, SASCOG, has commended the Corporate Affairs Commission, CAC, for recording another milestone with the recent launch of the Beneficial Ownership Register, BOR. Now, the commendation was contained in a 12-point communique read by its President General, Comrade Kayode Sirajuddin Alakija, at the end of its meeting in Jos, Plateau State. The SASCOG National Executive Council noted with delight that CAC's BOR became another record breaker as the first of its kind on the African continent. It also commended the Commission's enforcement activities, especially the recent move to strike off 100,000 dormant companies from the register, describing the move as capable of sanitizing the business environment to attract foreign direct investment to the country. It therefore charged the Commission, under the leadership of Alhaji Garba Abubakar, to sustain the gains of the project as well as continue to improve its services in line with global best practices. Now, the SASCOG National Executive Council also used the forum to commend the judiciary for another landmark judgment by the Court of Appeal in the case of SASCOG and APPLAUDS, in which judgment was given in favor of SASCOG. The Court of Appeal held on Friday, July 28, 2023, that SASCOG reserved the right to unionize senior staff from Level 7 and above in all statutory corporations and government-owned companies, while APPLAUDS can only unionize junior staff from Level 6 downwards as provided by the labor laws. The judgment was the aftermath of an appeal instituted by the Amalgamated Union of Public Corporations, Civil Service, Technical and Recreational Service Employers, APPLAUDS, against the Senior Staff Association of Statutory Corporations and Government-Owned Companies, CAC'S. The appeal was against the judgment of the National Industrial Court sitting in Abuja in suit number NICN ABJ 125/2019, delivered on December 17, 2019 by Honorable Justice O.Y. Anuwe. The notice of appeal, which was filed on December 20th, 2019, contained 6 grounds of appeal. CAC Weekly reports that Justices of the Court of Appeal, Ugochukwu Anthony Ogaku, Muhammad Mustafa, and James Gambo Abundaga all consented to the landmark judgment, which put to rest the arguments surrounding the jurisdictions of the two unions. The National Executive Council meeting of CAC'S concluded by resolving to cooperate and work in harmony with all tiers of government and also with the management of member agencies. It pledged to uphold the provisions of the Constitution of the Federal Republic of Nigeria, the Trade Union Act, and the Nigeria Labor Law to ensure all-inclusive, good corporate governance that will engender mutual growth in organizations.
NEC in session is also calling on the federal government to look into the economic pattern behaving in the country, especially as it affects Nigerian workers. The rising inflation in the country is becoming alarming. Hence, meeting the needs of common man is becoming practically impossible. An urgent step needs to be taken to rescue the citizens, especially Nigerian workers. NEC in session commends the Corporate Affairs Commission for the recent launch of Beneficiary Ownership Register, which brings Nigeria as the first country in Africa to start registering beneficiary ownership of company. The Beneficial Ownership Register is in accordance with the global best practices to stop corruption and money laundering. The Corporate Affairs Commission also commences the process of striking off companies from the registered company for lack of filing annual returns for 10 years. Therefore, the company registry is calling on members of the public to file their annual returns and activate the status of the company for further transaction. The rising cases of insecurity across the country is very alarming. The issue of banditry, communal clashes, and hip-hop killings in the southeast, NEC in session hereby call on both the federal, state, and local government to put more effort in bringing an end to these unnecessary killings, and also bring out programs that will create jobs and employment opportunity for teeming Nigerian youths. NEC in session is calling upon the federal government to direct all ministry agents and agencies of government to implement the revised public service rule on 8 years tenure policy of directors, permanent secretaries, and equivalent rank, which take effect on 27th July 2023 as directed by the head of service of the Federation.
Now, CAC'S National Executive Council also called on President Bola Ahmed Tinubu to evolve a pragmatic approach to solving Nigeria's social, economic, and political challenges by engaging all stakeholders on all issues of national interest. We say congratulations to the Senior Staff Association of Statutory Corporations and Government-Owned Companies, CAC'S, for that victory. Now, moving on the program, the Institute of Chartered Secretaries and Administrators of Nigeria has applauded the milestone achievements recorded by the Corporate Affairs Commission, CAC. The Institute's president, Fumi Ekundayo, who stated this during a courtesy call to the Registrar General and CEO of the Corporate Affairs Commission, noted with delight that CAC's reform initiatives led to improved service delivery. Ekundayo stressed that the Institute was at the Commission to, among others, appreciate its achievement under the leadership of Alhaji Garba Abubakar. She therefore said that, as a stakeholder, the Institute was ready to collaborate and partner with the Commission on ways to further enhance service delivery for the benefit of the economy. Responding, the Registrar General and CEO of the Corporate Affairs Commission, Alhaji Garba Abubakar, thanked the Institute for its support and encouragement over the years. Alhaji Garba Abubakar, while responding to some concerns about the Commission's striking off policy, maintained that the idea was not conceived to generate funds for the Commission, but rather to engender compliance, strengthen its records in line with the Beneficial Ownership Register (BOR), and conform with international best practices. The Registrar General explained that companies that have already been earmarked for striking off were expected to comply within 90 days. Failure to do so will lead to eventual delisting. Garba Abubakar therefore revealed that about 100,000 business names and 10,000 incorporated trustees who have defaulted in the last 10 years would soon be published for striking off from the register in accordance with the provisions of Section 692 of the Companies and Allied Matters Act, CAMA 2020. So now hurry to update your records to avoid being struck off the register of companies and the attendant consequences. It is now time for us to move to our interview segment where Tolulope Adeola Shonaike gives us more insight into Africa's Beneficial Ownership Register, BOR. Enjoy watching.
Mr. Tolulope Adeola Shonaike, many thanks for joining us on the program.
Thank you very much. Thank you very much.
All right. Today we'll be looking at statutory books that are supposed to be kept by companies. I don't know how many companies, because I'm seeing a long list here, over 10 of them. So I don't know how many companies know about these books.
Okay.
Talk less of, even keeping them.
Yeah, company proceedings and records are very, very important, and for institutional memory and compliance requirements, companies are required to keep certain records. Such records will include index of members, register of members, register of persons who safeguard control, which is a new element. And then you have the requirement, you also have the obligation to keep copies of instruments.
What do you mean by instrument? Before you start thinking of musical instruments?
No, instruments will mean documents, agreements, that form or create what you call charges. Now, charges are what you call encumbrances on property. They are like burdens, obligations, flowing from flowing from borrowings. And then when you borrow, it's expected that there's something charged to secure that borrowing.
Okay.
Something that you put down. So I may borrow and say, okay, you know what? This is what I need 1,000 naira for you. This book is worth 20,000 naira.
So is that the collateral?
Something like that.
Okay.
So the legal term will be charged. Okay. So you have created a charge on the book.
Okay.
So and companies need money to prosecute their objectives. So sometimes you find that companies will borrow, just like human beings also borrow, to be able to fulfill some obligations. So you find that companies borrow money, but then the lender is not necessarily a charity. It's not a Father Christmas. So if he's giving you money, it's also in the business of lending. And even if it's not in that, it's not for profit. He wants to be sure. Yeah. Even if he doesn't want to make profit, he has to be sure that at least the principal you return back to him. Okay. So to secure that, look, what are you putting down as collateral? Just in case you fail to pay back, something I can follow to at least get my money back. Okay. So every instrument creating such arrangements by a company, as long as it touches on the property of that company, the law expects that you make copies of that instrument to keep them. Then you have what you call the register of the charges now. Don't forget that one is the instrument itself. Okay. So every agreement, file them and keep them. Then you have a register that will now detail the charges. Now this register will just give you highlights of not everything that you have in the instrument, right? And then you have the register of debenture holders. What again is debenture means you are owing.
I think when we come to them one after the other.
So you have the register of debenture holders. You also are required to keep minute books. Minute books relate to meetings. Okay. There are different classes of meetings that a company can hold or that can be held within a company. You are expected to keep the minute books. You are also expected to keep registers of directors' shareholding. It's not in all cases that directors hold shares, but in cases where they hold, you must keep a register of their shareholding. Okay. Then you must keep a register of the director's residential address.
Okay. Very important.
Where they live. And then this new law, last Council 2020 has introduced what you call a service address. So you want to keep a record of the residential address vis-a-vis the service address. Then you are expected, if you are a public company, to maintain a register of the secretaries, company secretaries. But that applies only to public companies.
Because when you say secretaries, I'm wondering how many
company
secretaries.
Company
How many secretaries are supposed to be
those
in the company?
who provide company secretarial services for you. It may be in-house, it may be outsourced. Then you are also expected to keep records of accounts, what you call accounting records. Right? So all these records, there are prescriptions as to where to keep them, where they should be kept, and in some cases, how long you should keep them. And where you don't comply or fulfill those requirements about the content, the place, the location, and the duration, then there will be sanctions that will be applied.
But from experience, how many companies keep this records?
Again, when you say from experience, that will mean, because we can't know from the commission except we go out.
Okay.
So from time to time we go out.
Okay.
Right? You find quite a few, a number of them keep the records. Right? But what you always find is that some try to keep the record, but they don't keep it in the form they should be kept.
Okay, so they have a special form.
There are things that are supposed to be in there.
Okay.
And then, for instance, where you have you are required to keep an index of members, for instance. What is an index? Some people will tell you that because they have kept the register of members, they have fulfilled the requirement for index. No, the register of members can be kept. It doesn't have to be chronological. It doesn't have to be alphabetical.
Okay.
Right. So long as the name of every member is in that register,
then it's good to go.
Right. But when you say an index of members, an index is kept in such a way that it is easy to locate anybody you are looking for, any member in that register. So ordinarily an index will be kept either chronologically or alphabetically, either by number or by alphabet. It's not every company that must maintain an index. Index will only apply to any company that has more than 50 persons as members of the register. Right. Now, when you are expected to keep an index, you are supposed to keep it alphabetically. So you must get an M before an A. So that where I'm going to look for, this person is who I want to see. And then we have more than 50 members. Yes. I don't need to be searching one by one before I get to. I should just go to where you have M to search for Medina. Yeah. That's indexing for easy retrieval, to locate that information in the register where it is. There's a reason why the law says you should keep it that way. And then the things the law is interested in as entries, just put them in the law. You understand? It's about the adequacy of the information. So let it be enough to the extent that the law requires. Okay,
what is the sanction for non-compliance?
Usually for these records, if you don't comply, because the duty to ensure compliance lies with the directors. Right. So usually the sanction will be against the director at the company. So usually they will be in the form of a daily penalty. You don't only maintain this and keep this record, you also update them. So if there have been changes in the information contained in the record, you are supposed to update that information in the record and then notify the commission. Right? Because if you are talking about your register of members or registers, well, that what we have in the CAC may not represent at all times the current membership. Because ordinarily, a company is not required under law, even though by practice we allow them filing. They are not required under law to notify us immediately there is a transfer of shares. No, we only know about that when you come and file your annual returns. Because if you were to keep notifying, companies keep notifying the commission about transfers of shares, in the case of public companies, it will be very, very difficult to keep up. Because somebody can hold the company of a public, the shares of a public company now, and before the end of the day, he sells it again to another person. So you can't be filing, if you want, you can't keep up. Yes. But if you go to their registrars or the company itself sometimes, they will have that record.
Let's take them one after the other. And I can see the first on your list is the beneficial ownership register, or popularly known as persons with significant control.
Yes. That's, like I said, that came with CAMA 2020. Before this time, there was no obligation for companies to maintain a register of beneficial ownership or persons with significant control. What we had before now, which was Section 94 of 1990 CAMA, only required, did not actually require, but permitted allowed public companies at their own election to require their shareholders to disclose capacity in which they hold shares, whether the shares are held for their own benefit or for the benefits of some other persons, right? So you find that in that instance, under CAMA 1990, a public company did not apply to private company, only applied to public company. So a public company can choose to and can choose not to. So there was no obligation whatsoever. But then following, and you can understand why that would be. So at that time, the issues that face us now that we contend with were not the issues we were contending with. The issues of insecurity were not a concern then, right? The issues of banditry, money laundering, tax evasion, all of these illicit flow of funds, right? They were not issues then. We didn't really have a global economy, So at that time, the issue then, the concern was to guide against surreptitious takeover of companies, right? That was why the company would say, look, we see what is happening. Please, are you holding those shares for yourself or some other person? We need to know who and what quantum of share each person is holding, so that if it's getting to a point where maybe the person is trying to do a takeover, we need to know.
Who the president is, yeah.
So, but today, the concerns are different. You have concerns of money laundering, you have concerns of tax evasion, flow of illicit funds, corruption. And that had now become, those issues have become concerns for not just Nigeria, but globally for every economy. So increasingly, jurisdictions are compelled to do what is not traditional. The traditional thing is that you don't go behind a company to know who the person is, except that you are investigating. Ordinarily, no, you shouldn't. Because the company is different from the person. That's the principle of separate legal entity, corporate personality. The company enjoys legal personality, different from those who float it, right? So the actions of the company stay with the company. It doesn't, except you can now say there is fraud or there isn't the company to perpetrate fraud. Okay. But now you call it corporate veil. Corporate veil. You only lift that veil in exceptional circumstances. But today, company law has assumed a dimension that you don't wait until there are those exceptional cases. You must disclose. So it's a way of lifting the corporate veil.
Okay.
So we know the people who are behind it. The only thing there is that even though that information is available to us as a registry, we don't put it on the public register. So people don't see it, right? You don't disclose it to the public. Again, the records that are with us by law are public records, right? But you don't display this personal information as public information. So today, you are required to give us that information. You obtain that information from the person himself. Okay. The person gives it to the company or the limited liability partnership within 7 days of assuming that status. Okay. And then the company or the limited liability partnership is required by law to notify the CAC within a month of getting that information from that person. The company itself is required to maintain a register of beneficial ownership. Now, when the CAMA came, our own expression is not beneficial ownership. In the law, you find person's physical control. Yes. Right? So the person's physical control by regulation that were subsequently made is the same thing as a beneficial owner. Who is the beneficial owner? The beneficial owner is the person who ultimately, the natural person, individual, the ultimate individual, who enjoys the benefit, right, of equity or participation in a company or limited liability partnership. That participation, that equity or right will come either by shareholding or by voting rights or by mere exercise of control, significant control, right? So if it's about shares, the threshold for disclosure is 5%. Okay. So anybody who holds at least 5% in a company shares, right, total shares, if you hold 5% or more, you must disclose the capacity you are holding. Okay. Whether it's
even if it's very tiny,
it doesn't matter. So long as it meets that threshold.
Okay.
You must disclose.
Many thanks indeed for your time, sir, as always.
Thank you very much.
What a great insight there from Tolulokpe Adeola Shonaike. It is on that note now we come to the end of this week's edition of the program, CAC Weekly. We, however, do hope you enjoyed watching. Remember, for comments and inquiries, you can please take advantage of our social media handles and our call center. On Twitter, it is at CAC Nigeria 1. On Instagram and Facebook, it is Corporate Affairs Commission. Our email is cservice@cac.gov.ng. You can visit our website via www.cac.gov.ng and our call center on the number 070-806-29000. Join us again next week for another interesting edition of the program CAC Weekly. Same time and same station. I am Amina Jibril, saying bye for now.